What's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota, although I'm broadcasting to you live from a swanky hotel in East Texas. Hey, guys. So welcome. So we'll see how this works. So far, the stream seems to be holding up, but I apologize for this being late. I have been really trying to get time to do this. I'm at a family reunion down in Texas, so I've been having trouble getting things arranged. This is how bad it is, guys. I am in a dry county. I don't have any liquor with me at all. So, so tonight's stream will be fueled by Red Diamond sweet tea. Because you're in Texas, you better have sweet tea with you at all times. 1, it's 1 billion degrees. 2, the sun is intense. And 3, sweet tea is delicious. So a dry county, it's actually not a dry county anymore, but we're talking very recently, within the past couple years. But a dry county is a county that does not actually allow the sales of alcohol. This county, until just a couple years ago, did not. But it's so freshly not a dry county that actually the only places you can buy any alcohol currently in this town, which is like pretty much the biggest town in the county, are grocery stores, and you can buy like 3-2 beer and maybe some wine. But for whiskey, I have to drive like 20 miles away. It's also a Sunday, so that doesn't really work. Thank you, Adam Robertson. When I look back on this day, I'll know. What's up, Mega Mobas? Welcome to the stream. So tonight I've got a little bit of a weird case that we're going to talk about. This is about a subject that we have covered elsewhere. This is Russell Greer suing the state of Nevada on behalf of incels. And no, I'm not kidding. That's what is the primary incel of interest to him is, of course, himself. And he is tired of having to go all the way to Nevada to hire someone for the purposes of personal intimacy. And also, he had a falling out with a brothel owner in Nevada and was robbed of $4,000, apparently. So he is no longer able to even go to Nevada to get his personal intimacy. And he's also tired of trying to run from the law and hire these illegal sexual workers. And so he wants it all legitimate, and he has plans, and we're going to talk about all of that. So thank you again to Russell Greer for existing. Aaron, he was using brothels. He is no longer using brothels because he can't. I wish I knew what the falling out was. Look at that background. I just want to say that is fantastic. So instead of the liquor cabinet, you guys get a sterile wall. Oh God, this is just wonderful. Yeah, Keck, it's really nice. Well, only if you're in Utah. So if you want to get laid in the future is Utah. But he is running into trouble. So what we're going to be going through tonight is the explanation of Russell Greer's trouble. This is the decision of the lower court, the district court that has denied his initial petition. He is appealing this. So this is his appeal. And person whose name I can't pronounce because it is in some sort of language. Cyprin? I honestly don't know how to read that. But yes, state-mandated girlfriends, I think, are an actual goal of Mr. Greer. So, so join me. This is going to be pretty laid back because I'm not, again, I'm not sure how well the stream will pick up. Of course, with my luck, the stream will work better than it does at my house. But I don't have a ton of things set up for this. We're going to go through this document, and that's what I've got. But I'm hoping to have some more time during this vacation to get some stuff put together. But these first couple days have been all family reunion, so that kind of makes it a challenge. And then I'm in a small hotel room, and I don't have an escape. I'm actually in the business center of this hotel. So technically, anyone could walk in here and start doing business. But as it's about 12:30 in the morning, I doubt that's going to happen. But, I have one more thing. Because I'm in Texas, there's a thing. Sergey Ladik. Well, welcome, Sergey. Sorry, I cannot pronounce your name. Well, sorry, I can't read your name. I can pronounce Sergey. But this is a donut. And this, I don't even know what this looks like on stream. Just a second. This is a donut. This is a weird looking one only because it was pushed up against, or no, not pushed up against the box, but it's been sitting upright in the box for a little while. So this is a Texas donut. And I've talked about this before, I think. But people who are not from Texas or like Louisiana, Mississippi, Alabama, maybe Georgia, they don't understand what this is and what a donut is meant to be. A donut is a light, fluffy pastry thing. Like, I'm holding it delicately because it will... No. You don't want a giant donut. Giant donuts aren't actually any good. I have to hold this delicately because if you can see, my finger is indenting this pastry just by barely holding it. And they dissolve. They melt into your mouth. They're delicious. No, see, Jacob, don't fall for the trap. Because these donuts, you get a dozen of them for $6. Okay? So you don't need a giant donut. You just need multiple of these little donuts. They melt into your fingers, yes, and into your mouth. And guys, they're seriously magic. So good. Yes, today, Brandon, it counts as me drinking because I am not drinking. Because I don't have any liquor. Well, correction. I was given a bottle of high gravity mead by Pizza Wolf. You can find him on Twitter, Pizza Wolf. Great guy. Got to meet him. Very awesome. I was given this bottle of high gravity mead, and I don't. It's back in my hotel room. I don't have it out here, but I was told that it needs to age like another 6 months to a year before it's really good. So I'm gonna let that happen. Other than that, that's the only liquor that I have with me because I was planning on picking up some whiskey, but I didn't. Dunkin' Donuts BTFO live on camera. Yeah, Dunkin' Donuts they're just not good. Sorry. But let's see. Check out Ranger Creek 36 caliber whiskey. Yes, I'm probably going to the nearby liquor store tomorrow. But like I said, it's about 20 miles away, and I haven't really had an opportunity to go. But But in Texas, I eat donuts for breakfast every morning. Donuts and kolaches. Not the fruit kolaches, though, the sausage ones. This is like highly professional live stream, but you guys got to know. You got to know what goes on in my life. I don't know why you got to know, just because I feel like telling you. Because I want to share my joy. I like Dickel's whiskey, you say. Yeah, I need to try some Dickel's whiskey. But I don't know what I'm going to pick up tomorrow. But I'll let you guys know, because I'm going to grab a bunch. My uncle suggested a good whiskey. I don't remember what it's called, but it's the first legal Texas whiskey that there was. And they're still around. So I'm going to grab some of that for sure. I tried to grab some Kansas whiskey while I was in Kansas, but the liquor store that I went to was really small. They didn't have anything good. All right, guys. Let's get started. Because we do have about 30 pages of documents, 29, I think. We've got this front thing. Look at everybody who Russell Greer has sued. We have sued. Oh, thanks, Adam. I really appreciate that. He has sued Gary Herbert in his individual capacity as governor, Sean Reyes in his capacity as attorney general, Sims Gill in his capacity as district attorney of the city and county of Salt Lake, Jackie Biskupski in her capacity as the mayor of the city of Salt Lake, Ben McAdams in his capacity as the mayor of the county of Salt Lake, Kathy Berg in her capacity as director of the Division of Commerce, James Allred must be a commie, in his official capacity as business licensing manager for the city of Salt Lake, and Roland Yoshinaga in his official capacity as director of planning and development for the county of Salt Lake. So that's kind of the weird quirk of suing the government. You can't really sue cities, municipalities, and governments as entities. You sue the people responsible for the decisions in their capacities. That's how you get around that whole thing. It's just a dumb quirk. They should just seriously allow you to sue the state of Utah and the city of Salt Lake or whatever. If this lawsuit is in support of state-mandated girlfriends, I fully support this lawsuit. Spookmeyer, not quite, but follow with me. Aren't Mormons big in Salt Lake City? Maybe they'll rule in his favor just to be nice. Russell Greer, as far as I know, is a Mormon, and he did attend the Latter-day Saints Business College. I'm not positive. I don't want to comment and say... I don't want to make some commentary on Mormonism or his affiliation with the church or their support of him or anything like that, but I believe that he is a self-described Mormon. Someone is welcome to correct me if I'm wrong on that. There are many Russell Greer experts that are certainly more versed in his antics than I am, although I'm trying, because everything I read of his is pretty funny. So this is the decision of the judge. And let's go through it. So just so you guys, this will give you some exposure to a district court ruling, what they look like. They can be lengthy at times, but this is about 29 pages. City always seems to pay for legal fees and settlements. Yeah, sometimes. All right. So introduction. And there's already a footnote. You have a footnote on your first word, Judge, and it's a subheading, so good job. Introduction. All parties in this case have consented to the United States Magistrate Judge Dustin B. Peed conducting all proceedings, including entry of final judgment, with appeal to the United States Court of Appeals for the 10th Circuit, docket number 24, see 28 U.S.C. section 636C. All right. Russell Godfrey Greer wants to provide everyone with safe legal, quote, access to intimacy. In order to do so, he seeks to open a Utah brothel called the Mile High Neon. Under Utah's current laws, however, he is prohibited from doing so. Footnote 2. See Utah Code annotated section 7610, 1302 through 1305, criminalizing prostitution and solicitation, and declaring brothels a nonsense in a later section. Consequently, Greer filed his federal declaratory action challenging the constitutionality of portions of Utah's laws criminalizing prostitution, solicitation, and the operation of brothels. Gee, I wonder how that's going to go. If you guys don't know, the constitutionality of making brothels illegal is a long established non-infringement of anyone's constitutional rights. So I'm sure Greer has a nice theory to it, and it's a bold strategy, Cotton. Let's see how it works out. Factual background. The following facts are taken from plaintiff Russell Greer's amended complaint and viewed in a light most favorable to him. So this is less incel and more libertarian. Kind of, yeah. So, footnote. When considering a motion to dismiss, the court accepts all well-pleaded facts as true and views them in the light most favorable to the plaintiff. And now, when it says well-pleaded, they're not actually commenting on the quality of the pleading of the facts. A well-pleaded fact is something that is not deficiently pleaded. It's not like well, this is a good point or a good fact or something like that. It's just this isn't what they say isn't problematic for various reasons. And the court, quote, must view all reasonable inferences in favor of the plaintiff, and the pleadings must be liberally construed. So they can't narrowly read this stuff, and it has to be read in favor of him. So everything the judge says for the rest of the section pretty much is straight out of Russell Greer's initial complaint. So you'll notice from the first line where that factors in. Plaintiff is a well-educated, footnote 4. In the summer of 2015, plaintiff graduated from LDS Business College. Prior to graduation, Greer completed an internship in the litigation division of the Utah Attorney General's office. Now, mind you, he is suing the Utah Attorney General, who I'm sure is really happy he accepted this guy as an intern. You did not miss your plug, Pizza Wolf. I mentioned the bottle that you gave me of mead, but I have not done the official plug. I want to do that on a live stream that is less hectically thrown together. So do not worry. We'll do the full plug very, very soon on a live stream, and I'll do it on a video too. But no, you didn't miss much of anything. I did mention, yes, I am in a dry county right now. Well, no, I'm in a formerly dry county. Let me be clear. It is formerly dry, but yeah, I have not been able to actually purchase any other liquor, so I have sweet tea, which is a close second. But yeah, I'm gonna talk to you guys about this wonderful place that I visited in Dallas in an upcoming video, and encourage everyone to go there, especially to make arrangements. No, you're fine. Don't worry about it. That's responding to you, Pizza Wolf. There's Listerine in your room. There is, and it does have a nice alcoholic tinge to it because it's cheap stuff. Arab Andy has a GoFundMe. He's raised $911. I gotta send another PM to him on Twitter because I talked to his manager, but at the time I talked, he had not actually spoken with Arab Andy yet. Presumably he was still in jail. So, all of this talk of dry county has me hearing Bon Jovi songs. Please apologize. Like you don't like Bon Jovi? What Bon Jovi song has dry county in it? That's fantastic for the Arab Andy stuff. Okay, let me get back to this. So, yeah. Plaintiff graduated from Latter-day Saints Business College. Prior to graduation, he completed an internship in the litigation division of the Utah Attorney General's office. He was born with Mobius syndrome, a neurological condition that causes facial paralysis and prohibits him from closing his lips or moving his eyes sideways. And then that's just footnoted. Doesn't really matter. Greer's disability causes significant physical and social challenges for him. Consequently, in order to feel loved, Greer solicits sex workers. Footnote. But before that, Adam Robertson says, shout out from Colorado. Let's crack one. Yeah, buddy. Thank you very much. I appreciate that. And I love Colorado. I need to get back out there. We used to go every other year, but we got kind of sidetracked on some other vacations and fell out of it. But man, Pagosa Springs is seriously my favorite place on this planet. So, all right. So solicit sex workers. So footnote, Greer refers to prostitutes, escorts, and sex workers interchangeably throughout his pleading. While there are subtle nuances that differentiate these terms, for purposes of this opinion, the court broadly defines all prostitutes, escorts, and sex workers as individuals, quote, who engages, offers, or agrees to engage in any sexual activity with another individual for a fee or the functional equivalent of a fee. That's from the Utah Code. Fun fact, according to their wiki, LDS Business College only offers 2-year degrees. Yes, his degree is a paralegal degree. So, highly educated with a paralegal associate's degree. And guys, that is not a slam on 2-year degrees or on paralegals or on associate's degrees in any way. It's just an interesting perspective to consider that highly educated. But that's what I was getting at with Greer writing the facts, the court just accepting those facts because that's how courts have to do this. But, you know, the Bon Jovi song Dry County features the phrase prominently. Oh, I'm not familiar with the song Dry County. I'll look it up, and then I'll use it to haunt your dreams. It's the great shame of Texas. For as many dry counties that there are, there's an open container law that was repealed, I think, but old men don't give a crap. Yeah. Okay, so he solicits sex workers at brothels in Nevada where prostitution is legal, and in Utah where prostitution is criminalized. There's a footnote, but it's just to some of the statutes. In April of 2013, Greer started visiting brothels in Nevada. He visited brothels in or near Elko and Reno, Nevada. He describes his experience as magical and claims that his time there helped him to, quote, cope with his disability and depression. Over time, frequent travel to Nevada became financially prohibitive. Greer estimates he spent up to $14,000 at brothels in Nevada. And Greer was forced to seek companionship in Utah. Additional reasons for Greer's decision to stop traveling to brothels in Nevada include a falling out with his brother with brothel owner Dennis Hoff and becoming the victim of a $4,000 theft. This guy is just it's just too much. He runs into bad times. So prostitution is illegal in Utah, and plaintiff lived in fear of being victimized. Footnote 13. Plaintiff claims he has been the victim of fraud when escorts post, quote, fake pictures to lure Greer in and upon meeting, hold him under duress to give them the money. Others have been the same girl as advertised, but they do not provide the services they promise. Yeah, man. I mean, I guess if you're using like the Craigslist list as your brothel, you're not getting a curated list of the highest quality candidates. I hope he didn't give the court a transcript of his visits to Nevada. So he lived in fear of being victimized, criminally prosecuted, and of contracting a sexually transmitted disease. Determined to provide everyone with the opportunity for safe and legal, quote, access to intimacy, Greer decided to open a brothel in Utah called the Mile High Neon. The court will refer to it as TMHN, but I will refer to it as the Mile High Neon from now on. And we get a handy little footnote. The name Mile High Neon is a combination of the Mile High Club and the Greek word porneon, meaning brothel. And if you get nothing else out of it, if you get nothing else out of this case, get the word porneon, which is fantastic. The Greek word meaning brothel is porneon. Okay. Plaintiff outlines the Mile High Neon's business plan, design, layout, and operational procedures in copious detail. And here we get them. Footnote the copious detail. Dr. Richard R. Ape, is this is that an actual quote? I believe it is. I think I've seen it, but are you pulling my leg, or is that an actual quote? Because if it's an actual quote, I'll read it on stream in just a second. I mean, you can all see it, but oh man, good. We need to pass laws that make it a felony for a girl to say no to a person with a disability. Quote Russell Greer. Girls, if you turn me down on a date, it's technically discrimination because I have a disability. Parentheses, you know who you lovely ladies are. Close parentheses. Quote Russell Greer. Oh, what a lovely human. Chartreuse Kitsune. You would, I mean, maybe you wouldn't be surprised, but like in it's not always like this in opinions, but in like law journals and stuff, often that's the case. You'll see many pages where the footnotes take up more space than the rest of it. It's ridiculous. What's Porneon's attack move? I think it's disease, right? Okay, so use disease and depression, I would think. He's talking about Taylor Swift and Cara Delevingne, who he sent death threats to for turning him down. Not rape. Rape is not an attack move. Oh my goodness. Okay, so here we go. Let me read this. So this is his business plan. Greer explains that the structure will resemble a Greek temple with large columns, marble floors, and a wooden front door, similar to that found at a luxury mansion. A fountain will decorate the main room along with couches, televisions, and a non-alcoholic bar, because you wouldn't want liquor at your house of ill repute. An electronic business directory is located near the front of the building where clients can click on the girls' pictures if they are interested in meeting them. Past the office where financial transactions are conducted, there are approximately 10 employee rooms. Each room contains a window, bed, television, and panic alarm. Although we're not sure if the panic alarm is for the worker or for the client. The Mile High Neon also has a kitchen area where employees can cook their own meals. So he's offering some nice perks. A strong work environment. Why is this business pitch in the lawsuit? Well, buddy, it's the best question. Really tremendous. It is. It's because Russell is good at lawsuits. He has a lot of practice writing them. Plaintiff proposes, quote, innovative operational procedures for the Mile High Neon's employees. Weekly sexually transmitted disease inspections. Inspections? Like screenings is a less weird term than inspections. I don't know if I assume the court took inspections straight from it. So I guess there's like a team that will, kind of run the diagnostics and give the full look down. Self-defense training, financial planning, and training related to understanding the disabled. Very important in this industry. All workers are licensed through the sheriff's office, and the Mile High Neon will pay taxes and donate to local charities. Well, that's lovely that they'll agree to pay taxes. Potential employees may apply online, and the Mile High Neon will hire only, quote, the classiest and most beautiful people that have extraordinary personalities and who are not judgmental. Now, I don't know if he's planning on only hiring females or if he plans on hiring males as well. That's not clear so far. Employees are encouraged to set goals, and every 2 years, Greer will check to see if they're achieving their goals. So, guys, these prostitutes, escorts, or sex workers, whichever you want to call them, will be having employment performance reviews and goal setting, for their promotional needs. This is exactly when I worked at Wells Fargo. We had the same thing. We had to set, like 6 month, 1 year, 2 year goals, and we would have a manager come and bother us about if we were meeting our goals and achieving them and all that stuff, and what we needed to do to get where we wanted to be. So that was great. This is a good plan. I'm glad he's got this. We've got to make sure that these workers are on track for a solid future. Greer will encourage employees to, quote, go after their dreams and put them in touch with, quote, talent agents who can help find other, quote, non-sexual jobs. So that's good. That's good. I'm guessing that sex workers do need help finding non-sexual jobs. I maybe not. I don't actually know if that's a thing, but I find that kind of interesting. I'm not sure. So I don't know what the resume for the next job looks like for a person who worked at a brothel. But if you worked at a brothel legally, right, like in Nevada, and then your next job you're going to apply wherever, do you list the brothel as the former employer? I don't know the etiquette of that in resume writing, because brothels aren't legal in Minnesota, so I haven't had to run into this issue. Oh, we got another Greer quote. Taylor, I loved you with all of my heart, and I still do. This isn't some weird stalker attempt or anything. I've decided to file a $50 million lawsuit, Russell Greer. But didn't he went all the way to 100, though, Dr. Richard Ape. Okay. So then Greer will act as the Mile High Neon's legal assistant. So he's giving himself a job, but will not own or run the brothel. He's giving himself a job as the legal assistant. He can't be legal counsel for the Mile High Neon. So I don't know why the Mile High Neon would need a legal assistant. Seems like they would typically need counsel, but usually, well, I don't know. I don't know this plan. But will not own or run the brothel. Instead, he intends to give his business license to, quote, an educated, beautiful woman in her mid-30s to 40s who has higher education and expertise in business, or an experience in business. So I think he must have a specific person in mind, because that's fairly specific. Okay, so going back to the document. Wait, does he have... Tell me Greer beer is real. Okay, sorry. In order to obtain a license, Greer submitted his licensing paperwork online with the state of Utah. On December 29th, 2015, plaintiff's paperwork was approved, and he was given, quote, numbers for his business registration and the appropriate document to file. 16, that's just a boring footnote. On January 14, 2016, Greer received notice from Kathy Berg, director of Utah's Division of Commerce, that his registration was for, quote, an illegal business purpose, and it was immediately revoked. And that's another boring footnote. So I don't know how Utah works, but in Minnesota, when you file the appropriate paperwork to form like an LLC or whatever, they grant you the license before they review the documents. Frankly, like it's an automated process. And you submit your documents, and then you get it back. Then I guess they must do some sort of checking, or they have a flag system. I don't know. But then it appears that Utah has the same thing, and then they reviewed it. So apparently they came back and said, "Well, wait a minute, you're not opening a brothel. No, thank you. Not in the great state of Utah." Greer beer only sold at Mile High Neon. Man. Okay, on October 18th, 2016, Greer filed his initial complaint, which, see docket number 1 and number 2. Greer's initial pleading also listed Tricia Christie as a plaintiff. This is good. So I imagine Trisha Christie is the person he was going to give the business to. Adam Robertson says, "Drain your Greer beers." That's probably the first beer I'd like. Steel Comedy, they grant before the review probably because it's fast. So like in Minnesota, you can file for an LLC. It's presumably legal as long you can open LLCs and stuff as long as you pay the fees, as long as it's for a legitimate business purpose. So they're going to get way more legitimate LLC filings. The requirements in Minnesota and I assume in Utah are very, very thin. Like a name, an address, and a signature is pretty much it. So, most of and they process a lot of these things. So they just grant it quickly. And then they have some sort of other thing because, trust me, you want them to grant them first because you want to get on with your business. But like if someone goes to a bank to open an account for their business, but they haven't done anything, Pizza Wolf, I'm happy drinking tea. Don't worry. It's sweet tea is pretty much my favorite beverage. But if you go to the bank to like open an account, but you haven't actually done your LLC paperwork, you could literally pull out your phone, type up an LLC document if you know what you're doing, and submit it and actually get all this information right there. But another quote, "I'm reaching out to my bro Kanye again and his wife Kim to get my Taylor Swift case out into the open." Greer, I would love to promote your Taylor Swift case. I'll do whatever it takes. I'll be your spokesman, buddy. I'll put it on blast to everybody I know. Okay, so let's see. So he listed Trisha Christie as a plaintiff. I imagine Trisha Christie is the person he was going to give the business to, but the next line makes me smile. Christie did not sign the pleading or provide a physical address, email, or telephone number. So I'm guessing he probably didn't even ask this person if they would be involved in the lawsuit. So good job. So then there's a Federal Rule of Civil Procedure 11A. Every pleading, written motion, and other paper must be signed by at least one attorney of record in the attorney's name or by a party personally if the party is unrepresented. The paper must state the signer's address, email address, and telephone number. Further, as a non-attorney, Greer is prohibited from representing Christie in any case, and that's well-established law. So, good job. So later he sought to incorporate relevant statutory amendments and the court granted plaintiff leave to amend. Greer's filed his amended complaint on September 12, 2017, seeking declaratory and injunctive relief against defendants Governor Gary Herbert, Utah Attorney General Sean Reyes, and Utah's Director of the Division of Corporations and Commercial Code Kathy Berg, Salt Lake City District Attorney Sam Gill, Salt Lake City County Mayor Ben McAdams, Salt Lake County Mayor, not Salt Lake City, Salt Lake Director of Planning Roland Yoshinaga, and Salt Lake City Mayor Jackie Biskupski. That sounds pretty Polish as well. And Salt Lake City Business Licensing Manager James Allred, collectively the city defendants. Currently pending before the court are the city, state, and county defendants' motions to dismiss Greer's amended complaint for failure to demonstrate standing, state a claim, or establish a constitutional violation. Greer does not oppose city or county defendants' motions to dismiss, and the time within which to do so has expired. Good job, Greer. Okay. So let's read a couple of these footnotes. So footnote 20, Greer's claims against individual city, county, and state defendants are brought solely in their official capacities. In addition, Greer's amended pleading does not name Christie as a plaintiff, and therefore she is no longer a party to this action. So I'm guessing she never consented to any of that. And it seems like Greer is familiar with people who do not consent to his actions. So... so then the next footnote is District of Utah Civil Rule 71B3A and 71D. Failure to respond timely to a motion may result in the court's granting motion without further notice and granting motion to dismiss as unopposed pursuant to the rules. So he did not oppose their motions to dismiss. Greer has stated over and over that paralegals and paralegal specifically himself can do the same job as an attorney, but he failed to respond to the motion. So good job, Greer. Utah's process. So presumably the court is dismissing this partly based on that, which is a dismissal on the merits. Utah's prostitution and brothel laws. Greer seeks a declaration the following portions of Utah's statutes are unconstitutional. So I'm not going to read through these, but they're the prostitution, patronizing, aiding prostitution, exploiting prostitution, and declaring brothels a nuisance. Okay? So, on to the discussion. Standing. So this is the first claim. If you don't know, you have to have standing to sue. Like, it's said that anybody can sue anybody. Yes, but to survive a challenge to standing, you have to have typically a particularized injury, right? You can't just sue because someone has to harm you, and then you have to be able to bring that harm to bear through the courts to request redress. So they've challenged his standing. Like, basically, this dummy doesn't have the grounds to sue us because he wasn't harmed. Okay, so here we go. Standard of review. A threshold issue is whether Greer has standing to bring his claims against defendants. Standing ensures that federal courts only issue judgments in cases and controversies in which they have jurisdiction to do so. That's Article 3 of the United States Constitution, Section 2. The burden is on plaintiff to clearly demonstrate the elements of standing for each cause of action. Some of these footnotes aren't interesting, so I'm not going to read them. And the court has an independent obligation to raise the standing issue regardless of whether it is challenged by any of the parties. When considering dismissal, courts must accept as true all material allegations of the complaint and must construe the complaint in favor of the complaining party. So in this case, the court must accept as true all material allegations from Greer, and they must construe it in a light most favorable to him. So, welcome, Jaeger Mitchell. So then there's some footnotes, but these footnotes aren't really interesting. So then let's get to the standards here. Article 3 standing requires a plaintiff to meet the following elements. First, the plaintiff must have suffered an invasion of a legally protected interest, which is 1, concrete and particularized, and B, actual or imminent. So good job going from 1 to B, court. Not conjectural or hypothetical. Second, there must be a causal connection between the injury and conduct complained of. Goodness. The injury has to be fairly traceable to the challenged action of the defendant and not the result of the independent action of some third party not before the court. Third, it must be likely, as opposed to merely speculative, that the injury will be redressed by a favorable decision. Ryan English, what the heck? You're not allowed to drink while talking about Utah law. Well, I've got tea, man. I'm not drinking. We're good. Thanks, Ryan English. Buddy, I appreciate it. Okay, so yeah, the standing has to have... So the harm has to be concrete and particularized. You can't, make it up and pretend. Has to be actually... You have to actually have suffered it, or it has to be imminent. So you're about to suffer it. And then there must be a connection between the injury and the conduct. So when you're saying someone did something to you, that has to be the cause of what hurt you. Tea is on the list of things I can't drink in Utah? Oh, maybe. Can Mormons drink caffeinated beverages? Yeah. You're right. I don't think they can they? In addition to constitutional standing, a plaintiff must also establish prudential standing. Prudential standing places limits on who may invoke the court's powers and requires. The plaintiff generally must assert his or her own legal rights, so you can't sue on behalf of someone else. And the court must refrain from adjudicating generalized grievances most appropriately addressed by one of the other branches of government. So, a good example of prudential standing and lacking prudential standing is suing the government for the use of your tax dollars. okay? Because the harm isn't particular to you because a lot of people pay taxes. And even if everybody taxpayer got together and sued as like a class of taxpayers, it's a generalized grievance, and it's better addressed by electing different people that would change the policy. In theory, we know that's not actually true, especially in regards to taxes. They're always going to spend things on things that are stupid, or spend money on things that are stupid. But in theory, we should be electing new people. So, yeah. What Constitution is he talking about? He's talking about the United States Constitution. This is brought in federal district court. Well, I mean, I guess it could be the Utah Constitution, but I don't have the complaint. We'll see. They might get to that. I believe it's a U.S. Constitution. So state constitutions cannot protect less than the U.S. Constitution. They can only do further protections. So I would assume he's going after the U.S. Constitution because that's the minimum bar that has to be protected. But I don't know that for sure. They may address it later in the document here. So here we go. Okay, and finally, the plaintiff's complaint must fall within the zone of interest to be protected or regulated by the statute or constitutional guarantee in question. So in mounting a pre-enforcement claim, so this means someone is, goodness gracious. Pre-enforcement claims are you have not been arrested or fined or something for this. This is likely to happen if you proceed on your desired course of action. Welcome, Brett War. Thanks for joining, buddy. Okay, so mounting a pre-enforcement claim, plaintiff is not required to, quote, await and undergo a criminal prosecution before challenging the statute on constitutional grounds. Rather, a plaintiff may establish standing prior to enforcement by showing both a future intention to engage in conduct that is, quote, arguably affected with a constitutional interest but prescribed by a statute, and a credible threat of prosecution. So if he were to engage in acts that involve violating the Utah statutes against prostitution, he is likely going to be prosecuted. So that's there. The question is whether they're arguably affected with a constitutional interest or not. So, first one, Greer does not have standing to enforce the rights of individuals who choose to work in prostitution. So as a preliminary matter, Greer cannot establish standing to bring his equal protection challenge on behalf of individuals who, quote, choose to work in prostitution. So under the doctrine of prudential standing, Greer cannot bring suit to enforce the rights of others. Moreover, while an association may bring suit on behalf of its members, it can only do so if A, its members would otherwise have standing to sue in their own right, B, the interests it seeks to protect are germane to the organization's purpose, and C, neither the claim asserted nor the relief requested requires the participation of the individual members in the lawsuit. As an unestablished business owner, and the court ignores the fact that he says he wouldn't be the business owner, Greer does not identify any discernible association or members who otherwise have standing to sue in their own right. At best, plaintiff attempts to bring an equal protection claim as a future brothel owner on behalf of future brothel employees. Yet any currently unknown or potential future relationships are too tenuous to support representational standing, and Greer's equal protection claim brought on behalf of unidentified others is dismissed. So, yeah. He can't sue on behalf of brothel workers because, he doesn't actually have any brothel workers. So there you go, as employees. So Greer does not have standing to assert claims against city defendant Bikupski and all Redding County defendants McAdams and Yoshinaga. Greer does not demonstrate standing to bring claims against defendant Salt Lake City Mayor Jackie Biskupski, City Business Licensing Manager James Allred, Salt Lake County Mayor Ben McAdams, and County Director of Planning and Development Roland Yoshinaga. So the only allegation raised against City Mayor Jackie Biskupski is set forth at paragraph 12 of the amended pleading and states that defendant Biskupski is the mayor for the city of Salt Lake. She is sued in her official capacity only. Biskupski, an elected official, exercised the executive and administrative powers of the municipality. Likewise, the only mention of Salt Lake County Mayor Ben McAdams is at paragraph 13. Defendant Ben McAdams is a mayor for the county of Salt Lake. He is sued in his official capacity only. McAdams, an elected official, exercises the executive and administrative powers of the municipalities of the county. Plaintiff does not raise any substantive claims or assert an injury in fact. Absent a traceable injury, causation, and redressability, plaintiff lacks standing, and Biskupski and Allred's motion to dismiss are granted. So none of the allegations involve these people. He sued them even though they're not involved in that process. So Allred and Yoshinaga. The limited allegations raised against City Business Licensing Manager James Allred and County Development Director Roland Yoshinaga are found at paragraphs 15 and 16 of the amended pleadings, and they read the exact same. They read the exact same as the others, except for Allred's says Allred is responsible for overseeing the business licensing in Salt Lake City, which includes sexual-oriented businesses. And then Yoshinaga gets the same treatment for Salt Lake County. And additionally, at the paragraph 33, Berg, Allred, and Yoshinaga are compelled to not issue business licenses for those businesses deemed, quote, illegal, and therefore hinders plaintiffs' attempts from obtaining a license to try to amend state, county, and city laws surrounding houses of prostitution. That doesn't make any sense. So that's from the complaint. Sergey, good luck with your exam. Have a nice night. Thanks for joining us for a little bit. This paragraph that they just read, that I just read, 33, doesn't make any sense. He shouldn't be trying to obtain a license to amend state, county, and city laws. Like, that's not what you need a license for. You need a license to open a business. Weird. You got a license for that business, mate? Together, these allegations are insufficient to establish standing. In their official capacities, Allred and Yoshinaga oversee aspects of business licensing for Salt Lake City and Salt Lake County. Greer, however, does not allege that he applied for or was denied a business license by either. No substantive allegations are raised, and there is no concrete or particularized injury alleged. Without an injury, causal connection, or redressability, Greer cannot demonstrate standing, and their motions to dismiss are granted. Greer has standing to bring claims against county defendant Gill and state defendants Herbert, Reyes, and Berg. Greer demonstrates standing to bring claims against the defendant Salt Lake County District Attorney Sam Gill and state defendants Governor Gary Herbert, Attorney General Sean Reyes, and Director of the Division of Commerce Kathy Berg. Pre-enforcement challenge. Oh, excuse me. I apologize for the yawning, guys. I, again, had family reunion all day. It has been a little tiring. So as discussed, Article 3 standing limits federal court jurisdiction to clearly define cases and controversies where a plaintiff's injury is actual or imminent, not conjectural or hypothetical. That said, a plaintiff is not required to await the consummation of threatened injury to obtain preventative relief. Indeed, in order to establish injury under a pre-enforcement challenge to the constitutionality of a criminal statute, a plaintiff must show 1. An intention to engage in the course of conduct arguably affected with a constitutional interest but prescribed by the challenge statute, and 2. The existence of a credible threat of prosecution thereunder. A credible threat of prosecution exists when the challenge statute prohibits conduct that plaintiff wishes to engage in. The state has not disavowed any intention of invoking the provision against plaintiff. So clearly, he has not gotten special dispensation to open a brothel or engage in prostitution. So, there you go. So Gill, County District Attorney Sam Gill. Adam Robertson says, Nick is a sleepy boy, send him your energy. Thanks, buddy. I need it all. Like Vegeta fighting anybody. No, Vegeta doesn't take other people's energy. Only Goku does. Goku, the energy thief. County District Attorney Sam Gill does not dispute that he possesses authority to enforce Utah's criminal prostitution laws, and he provides no assurance that Greer will not be prosecuted thereunder. Rather, the thrust of Gill's argument is that any felony prosecution is too speculative to support standing, since it would require 2 prior prostitution convictions, solicitation of a child, or solicitation in unincorporated Salt Lake. Greer has not been threatened with arrest or prosecution under Utah's prostitution and brothel laws. Nonetheless, he asserts an objective fear of prosecution, quote, if he continues to engage in sexual activity for hire. The court lacks information on the regularity of the statute's enforcement. However, any assertion that enforcement is too speculative is undermined by the absence of any geographical limits on Greer's future engagements or solicitations. Absent parameters, it is possible that Greer's engagements will occur in unincorporated Salt Lake, an area where the district attorney is charged with prosecuting felony and misdemeanor crimes. Accordingly, under the somewhat loosened pre-enforcement requirements, Gill has authority to enforce the laws, and a credible threat of prosecution exists that is sufficient to support standing. Herbert Reisenberg. Oh, wait. Okay, wait. So there's a footnote here that's actually long. In so ruling, the court declines to adopt the state's argument that Greer's case is only, quote, a challenge to the ability to open a brothel and not a challenge to the legality of being able to solicit prostitutes more generally. Indeed, plaintiff challenges the constitutionality of Utah Code annotated 76101302B, which criminalizes the generalized legality of prostitution when meeting at an arranged place for the purpose of sexual activity in exchange for a fee or the functional equivalent of a fee. Additionally, the court finds Gill's ripeness argument unpersuasive, noting that contingent future events are always at issue in a pre-enforcement matter. Let's see. If a threatened injury is sufficiently imminent to establish standing, the constitutional requirements of the ripeness doctrine will necessarily be satisfied. Okay. Do you guys want me to talk about ripeness? Ripeness in cases? I'll just mention it really quickly. Basically, ripeness means that it's going to actually happen. It's not like a far-off thing. The violation is imminent. Felix, 1942, what's up, buddy? Welcome. So if a case is not ripe, it would be that like the violation is like too far or too attenuated to support the idea that it might occur. So the court wouldn't know if they would actually need to rule on this because there's no imminent danger of a violation of rights. This is to prevent someone from suing on some like really abstract legal theory that goes like way too far down some sort of rights rabbit hole, like a free speech provision is like, well, what if this and this and this happened, and then this happened, and this happened, and then this happened, then the court would need to intervene. Well, the court says, well, like, maybe we should just get to the point where that's actually happening. So, the violation is imminent is my new pickup line. All right, so state defendants Herbert, Reyes, and Berg concede that Greer has standing to bring his claims against them. Berg denies Greer's business registration for the Mile High Neon, denied, and Herbert and Reyes are responsible for promulgating and enforcing Utah's prostitution and brothel laws. Given the possibility that Greer may engage in the prescribed conduct in the future, a credible threat of enforcement and prosecution exists. And a threat of prostitution exists. 42 U.S.C. Section 1983. So this is a 1983 claim, which you may hear bandied about on this channel and elsewhere. So Section 1983 creates a federal cause of action to vindicate violations of constitutional law by individuals acting, quote, under the color of state law. Specifically, Section 1983 provides a remedy against, quote, every person who, under the color of any statute, ordinance, regulations, custom, or usage of any state, subjects or causes to be subjected to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws. So, standing alone, the statute does not create substantive civil rights. Instead, the statute serves as a procedural mechanism for enforcement of existing federal and constitutional rights. So, if you have, an officer who denies you some sort of right, or you have a person who denies you some sort of right by acting in their official capacity under the color of a law or regulation, then you would bring a 1983 challenge to do that. So in the context of civil rights action against multiple government actors, liability is predicated on each defendant's personal involvement in the constitutional violation. It is of particular importance, quote, that the complaint make clear exactly who is alleged to have done what to whom in order to provide each individual with fair notice as to the basis of the claims against him or her. Specifically, quote, when various officials have taken very different actions with respect to a plaintiff, the plaintiff's facile, passive voice showing that his rights were violated will not suffice. Likewise, insufficient is a plaintiff's more active voice, yet undifferentiated contention that defendants infringed his rights. You got to talk about what defendant did what. That's all. Let's see. Sean Thompson, you missed it because like my warning for it was poor. My planning for it has been poor. My ability to execute it was in question up until very recently. So you are not at fault in that one, buddy. To survive dismissal for failure to state a claim, a Section 1983 plaintiff must allege a 1. Violation of rights protected by the federal Constitution or created by federal statute or regulation. 2. Proximately caused. 3. By the conduct of a person. 4. Who acted under the color of any statute, ordinance, regulation, custom, or usage of any state or territory of the District of Columbia. As set forth herein, plaintiff does not assert violations of constitutional rights secured under the 1st, 5th, and 14th Amendments. Because Utah's prostitution and brothel laws are constitutionally sound, this judge should maybe fire their clerk for typing poorly. They cannot serve as a grounds of redress for Greer's 1983 claims. So, the court goes on to explain the constitutionality here. Utah's statutes are constitutional. Greer mounts several constitutional challenges to Utah's prostitution and brothel laws, claiming violations of 1. The right to sexual privacy. 2. Equal protection of laws. 3. The right to earn a living. 4. Freedom of association. 5. Article 1, Section 7 of the Utah Constitution. And 6. Prohibitions on vagueness. So vagueness, void for vagueness is a way where a law is so vague that while it does stop some, or no, it's unclear whether or not it would actually violate a constitutional protection. So some guy, gotta say which defendants did what. Sounds familiar. Yeah, if you've been following the lawsuit, very, very similar issue there. You have to talk about, because the defendant has to be able to say, I didn't do this specific thing, or I did do this specific thing, but here's why that's okay. So as explained herein, the challenge provisions are constitutionally sound, and defendants Gill, Herbert, Ray's, and Berg's motions to dismiss for failure to state a claim are granted. In addition, Greer's failure to establish a violation of rights protected under the Constitution also serves as an alternative holding for granting defendants Biskupski, McAdams, Allred, and Yoshinaga's motions to dismiss. Facial and as-applied challenges. I wouldn't blame the clerk. Would you continue to spell flawlessly if you had to deal with Greer's bull? Good point. Touche, my friend. Touche. I'm going to finish this donut because it's great. The best way to do any sort of broadcast is to eat during it. Well played, Mr. Robertson. A party may challenge the constitutionality of a statute under a facial challenge, an as-applied challenge, or both. More specifically, a facial challenge is a head-on attack on a legislative judgment, an assertion that the challenged statute violates the Constitution in all or virtually all of its applications. In contrast, an as-applied challenge concedes that the statute may be constitutional in many of its applications, but contends that it is not so under the particular circumstances of the case. Oh, a good donut. Where am I, Rackets? I am, you missed this earlier, I'm in a business room of a hotel in East Texas. So, I don't want to get too specific, but I'm down here for a family reunion. And speaking of which, if any of you are in Texas, I will tell you where I'll be. Friday and Saturday, coming up here, I'll be in Bremond, Texas for the Polish Festival. So if you're in Texas, if you're anywhere near Bremond, Texas, come join me, eating sausage, drinking whiskey, hang out, we'll have a good time. Pizza Wolf, that's not too far from you, buddy. Bremond's down by Waco, if I'm not mistaken. So if you want to come down for one of the days on the Polish Festival and hang out, definitely do so. Smurf, I will let you know if I go back through Chattanooga, Tennessee. It'll probably be, I don't know when we'll next be headed that way, but I do want to get back out east coast, because I have not spent much time. Adam Robertson says, drink time. Thanks, Adam. But, all right, so here we go. The distinction between facial and as-applied challenges is murky. One is not always categorically distinct from the other, and the line of demarcation may be fluid. At first blush, Greer's claims exhibit characteristics of both facial and as-applied challenges. Plaintiff titles his challenges as applied, yet the body of the claims reference application to many persons in Utah. Yeah, I figured, Pizza Wolf, but I figured I'd also let you know and invite you. Because, yeah, it'd be cool to hang out a little more. If things change by Friday or Saturday, let me know. When characteristics of both challenges are present, the court may consider other guiding tenets. First, labels that, quote, the parties attached to claims are not determinative, thus Greer's as-applied designations are not dispositive of the inquiry. Second, quote, the court must focus on whether the claim and the relief therein extend beyond the plaintiff's particular circumstances. Third, if the claim and relief extend beyond the plaintiff, quote, facial standards are applied, but only to the universe of applications contemplated by plaintiff's claim, not to all conceivable applications contemplated by the challenge provision. Lots of boring footnotes here. I'll keep you posted on that, Pizza Wolf. As set forth below, the court applies the appropriate analytical construct in conjunction with its consideration of Greer's constitutional challenges to Utah's prostitution and brothel laws. Plaintiff's 14th Amendment substantive due process claim for the right to sexual privacy. While labeled, quote, as applied, plaintiff actually asserts a violation of, quote, many individuals' substantive due process rights and raises a facial objection. So good job being wrong, Greer. The Due Process Clause extends constitutional protections to fundamental rights and freedoms protected under the Bill of Rights. Fundamental rights are, quote, deeply rooted in the nation's history and tradition, such that neither liberty nor justice would exist if the liberties were sacrificed. The relationship between prostitute and client is not a fundamental right protected by the Due Process Clause. Ryan English, I was thinking the same thing. I almost said, I'm sure Russell Greer hates facial challenges, but I held off. I was wondering if the judge is going to do it too. We'll see. Any fundamental rights analysis involves consideration of plaintiff's careful description of the asserted fundamental liberty interest, along with its historical roots. Fundamental constitutional protections have been afforded to persons' decisions and relationships such as marriage, procreation, contraception, family relationships, child rearing, and education. Similar protections have not been extended to the relationship between a prostitute and a client. So I'm guessing he's going for like a Ninth Amendment sort of thing where like all other rights not considered in other amendments are incorporated herein. Whatever. In support of his claim, Greer asserts sex and brothels is deeply rooted in this nation's history. Okay. Deeply Rooted has a joke in there too, but we're gonna stick with. I'll let you guys figure that one out. Additionally, plaintiff points to the quote ambiguity surrounding the Supreme Court's ruling in Lawrence v. Texas, striking down Texas law prohibiting homosexual sodomy. And guys, in the wedding cake video, I talked about this. This is where you've got someone who is taking a very, very specific read of or who's taking a very specific ruling and trying to broaden it out beyond what it's meant to do. Admittedly, the nature of rights protected under Lawrence is imprecise. Nonetheless, the Lawrence court acknowledged the case, quote, does not involve prostitution. So, there you go. Further, the Supreme Court's holding has not been interpreted as creating, quote, a liberty interest that invalidates laws criminalizing prostitution. Without a fundamental liberty interest, rational basis review applies. So, rational basis is the lowest level of scrutiny that the court applies to fundamental rights. And if you have a rational basis test, pretty much the government's going to win. I need to do a video on rational basis versus strict scrutiny versus intermediate scrutiny, but this is not that video. Utah's laws criminalizing prostitution are rationally related to legitimate government interests. Well, it looks like the court's going to do it for me. Under rational review, a statute must be upheld, quote, if there is any reasonably conceivable state of facts that could provide a rational basis for the classification. It's like the broadest thing you can possibly imagine. Review is highly deferential to state action, and the burden is on plaintiff to negate every conceivable basis which might support the legislation. So, Utah's prostitution and brothel laws rationally relate to legitimate governmental interests. In reaching this conclusion, the court takes judicial notice of the harms of prostitution as determined by other federal courts. Here's the footnote for this. A court is required to convert a motion to dismiss to a motion for summary judgment if it considers matters that are outside the scope of the pleadings. So this is Federal Rule of Civil Procedure 12D. If on a motion under Rule 12B6 or 12C, matters outside the pleadings are presented to and not excluded by the court, the motion must be treated as one for summary judgment under Rule 56. But a court is not required to convert a motion to summary judgment based on its consideration of public records for which the court takes judicial notice. So they're taking judicial notice of these other decisions, so they don't have to convert to summary judgment. It's still a dismissal. So, legitimate harms of prostitution include an interest in deferring the commodification of sex. The footnote continues. Facts subject to judicial notice may be considered in a Rule 12b6 motion without converting the motion to dismiss into a motion for summary judgment. It has been held that federal courts in appropriate circumstances may take notice of proceedings in other courts, both within and without the federal judicial system, if those proceedings have a direct relation to matters at issue. The state also asks the court to take judicial notice of the fact that 49 of the 50 states in the United States have chosen to criminalize prostitution, with only Nevada leaving that decision to the counties to decide. Okay, so going back here, legitimate harms of prostitution include an interest in, my trackpad is not working, deterring the commodification of sex, footnote 88. So this is Coyote Publishing Incorporated versus Milley. Observing that the 13th Amendment enshrines the principles that people may not be bought and sold as commodities, and restrictions on prostitution stem from an objection to their inherent commodifying tendencies to the buying and selling of things and activities integral to a robust conception of personhood. So, apparently the 13th Amendment prohibits prostitution. I do not buy that argument at all. Certainly there are people forced into sexual work, right? Sex trafficking is a thing that occurs, obviously, but there are also people legitimately and consensually trying to engage in this act. So I don't think the 13th Amendment is an ample defense. Plus, if the 13th Amendment were to prevent, prostitution, then obviously Nevada could not be one state that does legalize it. Prostitution is renting your body, not selling it. There you go. Well, and the problem with the whole slavery thing is that so long as the contract is not unconscionable, technically you could sell yourself. Like, you could sell your labor permanently to someone for some whatever fee the court would determine to be reasonable. Now that's, maybe a court would have trouble finding what a reasonable fee for a lifetime of work would be. But so long as you're doing it to yourself and it's not someone else doing it to you and overriding your own will, then what's the state's business in out doing that? Many of us sell ourselves to various corporations for work for basically a lifetime. So, and the court's just fine with that. So, along with findings that support a connection between prostitution and trafficking in women and children, there you go. Violence against women, illegal drug use, and sexually transmitted diseases. So now here's where the court starts to get into some better arguments than the 13th Amendment, and that's that various studies that have been used, and people can and do debate the validity of these studies and the methodology and all that, but that's not at issue here. What is at issue is that the courts have, throughout history, found at least these studies to be at least somewhat credible, and that's about all that you need in a rational basis test. Unless you're proving these studies outright false or showing that there's some methodological problem that negates the study, then the court gives deference to the state to use these studies and these sort of surveys to determine that when prostitution is around, violence against women increases, particularly violence against prostitutes. When prostitution is around, illegal drug use increases, particularly by prostitutes and their clients, and then sexually transmitted diseases. And the state has interest in curbing all of these things because all of them are threats to the public health and the public good. And state legislatures have that authority. So as does the national legislature have the authority to protect the commonwealth, provide for the common welfare, and provide for the public defense. Sorry, some weird stuttering. I'll make sure Maddox edits it out in post. Anyway, so, and again, when we're on a rational basis test, you only have to raise this issue and say that it's possible a state could be interested in protecting this stuff. Violence against women increases by 14%. Well, that's interesting. Thanks for that stat, buddy. Greer maintains criminalizing prostitution actually places individuals at greater risk of contracting a sexually transmitted disease or becoming the victim of a crime, and therefore no rational basis exists. Okay, that's boring footnote. The issue, however, is not whether Greer's basis or the basis offered by the state is more rational. Rather, the question is whether Utah's prostitution and brothel laws further a legitimate purpose. Here, they do. Which is a brutal sentence. Commercial sex is not a fundamental right, and Utah's laws prohibiting prostitution and the operation of brothels are supported by a rational basis. Catch you later, Sean Thompson. Thanks for joining us, buddy. All right, next, Claim 2, Plaintiff's 14th Amendment Equal Protection Claim for same end goal of intimacy. The Equal Protection Clause of the 14th Amendment mandates that, quote, no state shall deny to any person within its jurisdiction the equal protection laws. Equal protection requires the laws to afford similarly situated people like treatment. Greer concedes Utah's prostitution and brothel laws are neutral and apply to all persons who engage in prostitution. He argues, however, that the laws have a disparate impact on individuals with physical disabilities in violation of equal protection. So there's a disparate treatment and a disparate impact theory when we're talking about discrimination cases. What's up, Yuri? Welcome. Disparate treatment means that the law or the action actually treats a set of people differently than someone else, usually with intention, right? Disparate impact means it treats everybody the same, but the impact goes a certain way. I'll just, like in this case, he's saying that, sure, everybody's treated the same because no one's allowed to engage in prostitution activities. However, under the disparate impact theory, since this group of people is otherwise having trouble engaging in sexual activity without prostitution, there's a greater impact on this community than there is on everybody else. That's the statement. Let's see. So Greer asserts disabled people, quote, comprise a higher percentage of patrons who pay for prostitution services and are therefore at a higher risk of being arrested for soliciting prostitutes. I don't know where he gets that stat. He asserts it, and because we're taking this as a motion for dismissal, the court has to accept that assertion as true. But I would be... I don't know. I feel like I'd be surprised if disabled people comprise a higher percentage of patrons who pay for prostitution services. Like, higher than who? Are they the highest percentage, or are they just saying that they're disproportionate to the percentage of disabled persons that there are? I don't know exactly what he's saying here. As an individual with a disability, plaintiff's claim contains aspects of both facial and as-applied challenges, yet the relief requested affects the statute's application to the physically disabled. Accordingly, facial standards apply, but only, quote, to the universe of applications contemplated by plaintiff's claim. Assuming, as Greer has alleged, that Utah's prostitution and brothel laws have a disproportional effect on the disabled, a neutral law that disproportionately impacts a group does not violate equal protection, unless that impact can be traced to a discriminatory purpose. Greer does not allege any discriminatory purpose, so like they didn't make prostitution illegal specifically to screw the disabled people, pun intended. So he does not allege any discriminatory purpose and therefore fails to raise an equal protection violation. And even if alleged, any discriminatory purpose would need to support the unlikely contention that Utah's legislature enacted statutes prohibiting prostitution and brothels, quote, because of, not merely in spite of, the law's adverse effects on the disabled. Which you would typically prove either through statements of some of the people who supported it or something like that, or, you know, like debate on the floor. Could you imagine the Utah Congress debating their brothel laws and being like, you know what? You know who we don't like? We don't like the disabled, and we really don't want them to have access to prostitutes. There's no fundamental right to solicit sexual services, and Utah's prostitution and brothel laws bear a rational relation to legitimate government interests. Claim 3. This would be the most tiring part of being a judge, is like having to deal with, like, because they have to rule on every claim that's raised. So you'd have to sit there and go through each of these stupid claims and be like, oh. What's up, Dream Vikings? Welcome to the stream, buddy. Claim 3, violation of plaintiff's 14th Amendment substantive due process right to earn a living. Greer's third constitutional challenge alleges Utah's prostitution and brothel laws violate the 14th Amendment right to, quote, earn a living through one's chosen livelihood or profession, and to, quote, follow any of the ordinary callings of life, to live and work where one will, and for that purpose enter into all contracts which may be necessary and essential to carrying out these pursuits. Greer mounts a facial challenge on behalf of the many persons who seek to earn a living by engaging in the commercial exchange of sex. The language of plaintiff's challenge is identical to that raised by plaintiffs in the Ninth Circuit case, erotic services provider legal educators? I don't know. And research project versus Gascon. Legal education and research project versus Gascon. Challenging the constitutionality of a California statute criminalizing prostitution. While recognizing a fundamental right to make contracts and earn a living, the Ninth Circuit ultimately concluded there is no constitutional right to engage in illegal employment, namely prostitution, and plaintiff's claim fails. Consistent therewith, Greer fails to state a claim for a violation of a 14th Amendment substantive due process right to earn a living through illegal employment, prostitution. Don't look that up on Pornhub. Dude. Yeah, we were talking prostitutes, sex workers, and escorts, according to Russell Greer. So, you know, let me take a pause for a second, guys, and say that ultimately, I think prostitution should be legal. I'm not opposed. I'm not opposed to prostitution in principle. Like because I am for maximizing freedom where possible, and I think that if prostitution can be managed and people can engage it in a legal manner. We have a model of it that works, I guess, in Nevada. There are places that legalize it, and they seem to have some success and don't seem to suffer all of the, well, I mean, maybe they suffer the ill effects, but they don't seem to mind suffering the ill effects. I don't know. But, so like ultimately I agree with Greer that this should be a thing. I'm not interested in hiring prostitutes or anything like that, or going to a brothel, but other people are, and I have no problem with that. Again, it's not my place, or many, just about anybody's place to like determine the morality of our actions, and no matter what like various rational, legitimate purposes that they have for curbing prostitution, it ultimately boils down to moral policing. That's been going on for a very long time in this country. So, like, I don't care about Russell Greer's reasons for doing it. I don't care about the state's reasons for making it illegal, or their stated reasons for making it illegal. I know that the state does it because of moral policing, because they've done it for a long time, and I fully support people's right to whatever. I fully support people's liberty, we'll say, to engage in this sort of activity. So let me be clear. I'm not anti-brothel or anti-prostitution. I think Russell Greer is hilarious, and he does all of this in the worst ways. But in principle, I guess we agree. All right, so here we go. Next, Greer raises a facial attack on Utah's prostitution and brothel laws, claiming the statutes violate many persons' right to the freedom of association as secured under the First Amendment. Which I think is a problem, because no one is stopping them from freely associating with prostitutes. I hope the judge says that. They can freely associate with prostitutes all they want. They just can't contract with them for sexual activities. There are two distinct forms of freedom of association. One, freedom of intimate association protected under the Substantive Due Process Clause of the 14th Amendment. And two, freedom of expressive association protected under the Freedom of Speech Clause in the First Amendment. As an initial matter, Greer does not assert that the association between a prostitute and client is expressive. Further, Utah's prostitution and brothel laws do not criminalize associating or meeting with a prostitute. Thank you. They criminalize paying for a prostitute for sex. This association is not protected. Thus, even though Greer frames his claim as a First Amendment issue, his allegations are actually rooted in a claim for violation of the substantive due process claims protecting intimate and highly personal associations. As discussed, Greer's substantive due process claims fail because Utah's prostitution brothel laws do not burden a fundamental right and are supported by a rational basis. So Ryan English says prostitution is an unmitigated evil, but only those evils should be banned that directly interfere with others' rights. Yeah, I mean that's exactly where we go, right? What is it? The old adage is, if it doesn't break my leg or pick my pocket, right? Like in prostitution doesn't harm anyone except potentially the prostitute and the John. Although I think that's gender discriminatory. So, the John or the Jane. Do prostitutes in Utah have pixelated genitals? Yes. Yeah. Much research has been done on this, and that is a true thing. Claim 5, violation of Article 1, Section 7 of the Utah Constitution. Plaintiff argues the statutes violate Article 1, Section 7 of the Utah Constitution by depriving him of his due process rights. Okay. Like its federal counterpart, Utah's Due Process Clause provides that no person shall be deprived of life, liberty, or property without due process of law. Utah Supreme Court interprets the State Due Process Clause consistent with Supreme Court case law interpreting the Federal Due Process Clause. Accordingly, this court's analysis of Greer's federal substantive due process claim applies with equal force to plaintiffs' due process claims under the Utah Constitution, and as a result, Greer fails to state a claim for relief under Article 1, Section 7. Dun, dun, dun. Claim 6. Violation of constitutional prohibition on vagueness. In 2017, the Utah legislature changed the term house of prostitution to place of prostitution, which it defines as a place or business where prostitution or promotion of prostitution is arranged, regularly carried on, or attempted by one or more persons under the control, management, or supervision of another. Greer asserts the term place of prostitution is unconstitutionally vague because it arbitrarily allows law enforcement to, quote, to go after obvious brothels, but not go after legal places that may be practicing prostitution, i.e. strip clubs, massage parlors, etc. Utah Code annotated 7610-1304-13 is the only criminal statute challenged by plaintiff that is applicable to the operation of a brothel. Greer raises his challenge to the constitutionality of the statute in the context of a pre-enforcement review. Pre-enforcement review amounts to a facial challenge since no one has been charged to the court, so the court cannot evaluate the statute as applied. Moreover, because Greer's challenge does not implicate any conduct protected under the First Amendment, statute is reviewed on its face as unduly vague in violation of due process. To demonstrate that the law is impermissibly vague, it must be vague in all of its applications. Catch you later, Jacob Ceresia. I will check out that 36 caliber, buddy. Okay, so vagueness is rooted in the Due Process Clause of the Fifth Amendment, which guarantees that no person shall be deprived of life, liberty, or property without due process of law. A statute is impermissibly vague if it, quote, it fails to provide people of ordinary intelligence a reasonable opportunity to understand what conduct it prohibits, or, quote, if it authorizes or even encourages arbitrary and discriminatory enforcement. When reviewing a statute for vagueness, courts must indulge a presumption that it is constitutional and the statute must be upheld unless the court is satisfied beyond reasonable doubt that the legislature went beyond the confines of the Constitution. Upon review, the statute is clearly designed to regulate prostitution and includes a specific standard for enforcement, namely whether the place in question is used for prostitution or the promotion of prostitution. The law provides fair warning of what is prescribed, and in the pre-enforcement context, there is no allegation that the statute has been enforced in a discriminatory manner. Further, while a business that holds itself out as a brothel may be a more obvious target for prosecution, the statute provides a clear enforcement standard that does not encompass otherwise legal businesses. Consequently, the language of the statute is sufficiently clear that the speculative danger of arbitrary enforcement does not render the ordinance void for vagueness. Ruling in order. At its core, Greer's action stems from an impassioned belief that Nevada's system of regulating prostitution and brothels is superior to Utah's laws criminalizing prostitution. While engaging, Greer's policy-based claims that do not control, and it is not the role of this court to weigh the wisdom of the legislation. Utah's prostitution and brothel laws are rationally related to legitimate governmental interests, and any claim that the laws are antiquated and out of line with popular convictions is a policy-based argument that is appropriate for consideration by the legislature, not the courts. For the reasons set forth in this decision, the city, county, and state defendants' motions are granted, and Greer's amended complaint is dismissed with prejudice. Dustin B. Peed, U.S. Magistrate Judge. So, there we go, guys. That is the decision. H finally made it for a stream. Welcome. The stream is kind of winding down. Not necessarily, but we did just finish the legal documents. So this was Russell Greer's challenge to the Utah brothel restrictions. This is being appealed currently. So I actually pulled this from the appeal filing, but no motions in support of the appeal have been filed as of yet. I'll be watching it because I'm sure Greer, if he decides... So here's what happens. He does not respond to the motions to dismiss. It gets dismissed, and then he's going to have to overcome his lack of response on appeal, and that should be really sad. play the video of him dancing. Is Rackets in Yeehaw? I am in Texas, yes, if that's what you're referring to. It's not a Best Western laundry room. It's the business room. I'm at a Hilton Garden Inn, if you care. But, you know, I don't know. The internet seems to have held up just fine, so that's nice. I don't want to say where I am. Landau might serve me a document. Yeah, the internet can... Like, again, I joked at the beginning of the stream that the internet connection would probably be better here than it is at my house. And lo and behold, it hasn't dropped its rather steady rate yet. So, good job. Lack of drinking is my fault. Yeah, blame Pizza Wolf. That really nice and hospitable gentleman who gave me a wonderful beverage that I just have to let you know, age properly, because I don't want to ruin it. It's entirely your fault. By the way, it was very nice meeting you, and you and your dad there were great. So my wife even said that how much she liked your dad. Seemed like a really nice guy. She didn't say anything about you, which I thought was rude. Just kidding. She said that both of you were very nice. But, yeah. Oh, my goodness. So that's the scoop. That's what we've got with Russell Greer for now. I've got my eye on this one because I think Russell has some potential, and we'll see how that goes. You know, he's always up to something crazy, and I am, of course, watching his Taylor Swift lawsuit. I believe he just recently posted that $100 million default would be nice. Let me take a look. If you guys have not done so, you may want to just go to Russell Greer's Facebook page and give it a look. Let's see. Wow. So yeah, on June 16th, he posted $100 million by default. Yes, please, Taylor Swift. Marilyn Lim says, how long does she have to respond? He says 21 days. Tick-tock, the clock is ticking. 21 days from when? So he must have just served her. So we'll see. We'll see. And Adam Robertson says, last time around, let's drink. Yes. Yes. Drink up, guys. Drink for me. Drink, my friends. Yeah, or you could check the Encyclopedia Dramatica page and have a laugh. Absolutely. Can't wait for the Sean show on Tuesday. Oh, yeah, when the Dick show inevitably breaks up. All right, so I think the worst thing that can happen for Russell Greer is that Taylor Swift responds. Well, he says he said on June 16th he posted on his Facebook page that she had 21 days to respond. So I would think that would be his way of saying that he served her, but we'll see. I don't know. I guess if you give me a second, let me see if I can pull up. Just a second. My brain's broken. I'll check Pacer and see if he's got. Hold on, I just got to look up the number. So this is... Oh, come on. What am I doing? I keep looking at the wrong documents, guys. Sorry, I'm pulling up the case number. 180394. So I can pull up Pacer here. My cases. 18-0394. Search. I'll see if he's filed any proof of service here. That's what I'm going for. How did I do this wrong? Just a second. Did I do 003? Huh. Oh, mate. Hold on just a second. I might have this stupid thing. Nope. Hi. Party search. Sorry, guys. Really, there we go. Don't know why I couldn't find this before, but we've got it. Okay, thank you. Goodness, sorry, Pacer is going really slow for me. Yeah, he hasn't filed a proof of service with the court, so I can't verify that he's even actually asserting that he served it, but, you know, the case makes me think that he served it a couple days ago. But he's served her before, so he presumably knows how to do it. But I would think that the worst thing that'll happen is that she responds, because at this point, he's going to run the risk that her lawyers want attorney's fees from him. And that'll be a judgment he'll never get out of because, you know, he just doesn't have any money. So they'll just garnish his wages forever. And T-Swizz can actually pay the attorneys to do that. And if he were to bring another case based on similar grounds, he would really start to run into trouble. But, you know, 150 acres of land, huh, buddy? Nice. That's awesome. Well, guys, I think I should probably wrap this stream up. We're at an hour 45. I'm pretty tired. It's been a long day, and we're through the document, so I really appreciate you guys joining me tonight. Sorry for the short notice. I am going to try and just get a regular sort of video out sometime this week and talk about something good. I do have some pretty nice plans coming up, but have you seen video of this guy? He made a video about his Taylor Swift lawsuit. Wait, where? Sweet and sour pork. How long is his video? I love you back, buddy. I love you back. Do you have a link to it? Can you DM it to me on Twitter or something? Hold on, let me see. Oh, the one from 5 months ago? Oh, gosh. Yeah. Yeah. Oh, you're tempting. Oh, hey. Don't worry, it's back. It's back. It's back. Don't worry. The stream has stabilized, I believe. Okay, guys. Let me see. Do I have... So here's the problem with the video. Is the... Just a second. The problem with the video is that I don't have headphones. I thought I did. They must be in a separate bag. Yeah. Let's see. Let's see. Hold on. Just give me a second. Oh, man. Let's see here.
Taylor Swift did to me. 2017 has been the year of the hashtag.
Okay. Oh, boy. Okay. Let's see. Should we do it? Should we watch this video? I can pull it up on here. We can watch it together. I don't know how bad this is gonna get. Let's see here. Let me. Give me a moment. So look at that lovely OBS Studio default thing here. Hold on just a second. I'm just getting the link. I will be on the lookout for okay. All right. Scottius Maximus. Hello from England. I started a new job this morning, so I couldn't stay up for this live stream. We'll watch the rerun later. Keep up the good work. Thanks, buddy. I appreciate it. Yeah. Congrats on the new job. Oh, and since I missed it, happy Father's Day to all the dads who might be watching. Yeah, hold on. I'll get him fixed. Just a second. Hold on just a second. Okay, I can fix this. I had to sorry, I had to redo all my OBS stuff for this computer. But we're going to go back to the beginning. Okay. Let me just test sound.
Is Russell Greer?
Okay. So, what I'm going to do, because I want to be able to hear this, but not have it blast into my microphones, or into my microphone for you guys, and because I guess my headphones are in the other room, then, which I can't go into because there's a bunch of sleeping kids. I'm gonna mute my mic until there's something I need to say. Okay, so that's how it's gonna work. So
and I create this video to come forward with my claims about what Taylor Swift did to me. 2017 has been the year of the hashtag #MeToo, with stories that have brought to light harassment and brought about the demise of several high-profile celebrity careers.
And Taylor Swift, you are next. You are next. Okay, Dream Vikings. His mouth is shaped like that due to his Mobius syndrome, which is a facial paralysis syndrome. The courts described it. He's described it elsewhere, but it prevents him from closing his mouth fully. And we certainly should not mock him for any sort of disability or anything like that. We should only mock him for the ridiculousness of his ideas. So, here we go.
Like Harvey Weinstein. While many allegations have persisted of powerful and emotional sexual harassment claims by female victims, there are male victims as well.
I agree with Russell Greer here. There are male victims to sexual harassment, sexual assault, and certainly males should be participating in the Me Too theme, even if they're not like the movement. Because ignore the hashtag and the culture of hashtagging, but like the idea that that there are sexual harassment victims and sexual assault victims that are male is true, even though they have traditionally not been afforded the same sort of attention that goes towards female victims for whatever reason. That doesn't matter. This is 2018. Well, when he was recording this, 2017. So we need to move past that, of course, because it's current year. But, you know, and there are people who have been trying to call this out. What was it, Corey Feldman? because I think Corey Haim's dead, right? Corey Feldman had tried to call this out. Of course, he got run out of Hollywood for pointing this out, and you know, Anthony Rapp, I guess the guy from Rent, Mark from Rent, called out Kevin Spacey for assaulting him at some point. So here we go. Yes, that is some soft piano music in the background. Absolutely. So here we go. Back to it.
I happen to be one of those male victims.
Okay. I preemptively laugh just because I wonder if his victimhood is going to be comparable. And I assume he's going to tell us how he is a victim, I hope, so we can weigh it against it.
My question to you is, why does one need to be sexually abused to be a victim? I have been a victim of something in the corresponding tiers of sexual abuse, discrimination. After having suffered harassment and slander for my claims, I come forward now to affirm, under penalty of perjury, with my right hand raised, that Taylor Allison Swift discriminated against me because of my disability.
How? Okay. How did she do that? Guys, I gotta let him go. I'm gonna keep going. I'm gonna stop. I'm gonna mute over here.
Time, persons of the year do not do the others as she and her agents and her family have done to me. Good people do not shame and kick in the mud the stories and the efforts of those who put in effort for them.
I don't know if their perspective is the same as yours, buddy. I don't know if they see your effort as like a genuine effort, or if they see your effort as some sort of horrifying, potentially dangerous person that you appear to be. So, okay.
As you can tell, my face is paralyzed. I was born this way. I try not being upset and sad about it. You know, I have a college degree. I'm really strong. I like to work out. I have a cool beard, if you notice. But, you know, it certainly is a challenge. As a songwriter, it's a challenge to write songs and get it out there. My dream was to have Taylor Swift help me, and so I spent 2 years working on stuff for her,
He spent 2 years writing a 1.5-minute song. That's not working on stuff. That's 2 years writing a 1.5-minute song, which basically just combined a bunch of the titles of her songs into some semblance of a melody. I hate the mute button on this microphone.
And, you know, she said some really false things about me. And her agents, her agents, you know, they were completely negligent. And because of Taylor Swift, my life is destroyed.
I don't know if you get to blame someone else who literally doesn't care if you exist or not for your life being bad. Oh. Seg 2, does Mobius syndrome mess with your brain too, or is Greer just awful on his own? As far as I can tell, and I have not done extensive research, but I believe it's just related. It's just basically confined to the facial paralysis. The subsequent, well, I guess perceived insanity is all him. So. So, here we go.
It's like she wears a mask, and she's two different people. So...
It's almost like she has... I mean, just taking you at your word, yeah, she's a celebrity, and she has a public persona and a private persona. Those are going to be different. Like, necessarily... she's a performer and she's putting on a performance. So yeah, it's like she does have a mask. You know, although I don't think that's what you're talking about.
With this video, I call upon Time Magazine to retract their story of Taylor Swift and remove her title as Time Person of the Year. If they do not wish to retract their story, I ask that I am given the chance to tell my story the same way other victim stories have been shared. To deny me that right to share my story fairly is not only biased and unfair, it is arbitrary and sexist.
So deny him the ability to share his story fairly is not only biased and unfair, it is also unfair and sexist. Guys.
I'm not throwing around fancy words just for the heck of it, but it really is sexist. You're gonna say a woman can claim this, but a guy can't claim this. Either we're gonna hold all celebrities to a standard, or we're not. What's the point of coming out about stuff?
They do hold. They.
So, it is my sincere hope that this can be covered and shared. People need to know what Taylor Swift did to me.
What did she do? You haven't said what she did to you.
was lifted. You know, it's kind of like me too.
It wasn't high enough to read. No, Mary Likey, I think her agents are male, or at least the one that he like named. I'm pretty sure was a man's name, but I'm not positive. I can't remember at this point. But she untouched my pinay.
But I don't want to, you know, I don't know the word. I don't want to, you know, make other victims' stories less meaningful.
Don't worry. You in no way can make someone else's story less meaningful.
Because clearly there is a difference between sexual assault and discrimination that I think, you know, they both should be covered fairly. So that's why I use this hashtag, Swifted, because it's more appropriate because, you know, Taylor Swift destroyed my life basically. And so, you know, I wrote a book on it. So if I asked that Time Magazine cover my story, I asked that CNN, the Washington Post, Fox News, and other stations, please cover this.
You, Russell Greer, I will definitely cover your book. I will definitely cover your book. You can count on Lawsplaining the Interwebs, a 100% committed YouTube station to cover why I sued Taylor Swift. I have my copy. It's digital. And I will be reading it very soon. And I can't wait. So I will definitely cover it. I will sing it to the world, buddy. We're going to make this happen. You and me.
Taylor Swift needs to be held to a higher standard. And I deserve an apology from her. The news, you guys cover that guy who touched her butt. You know.
You guys covered that guy who committed an act of sexual battery against her. But you haven't covered me, who was specifically not touched. Sweet and sour pork. You need to start tweeting Cernovich, and if he ignores your tweet, you gotta drop Swifted on him.
That's stupid. That's the dumbest story ever. Stop covering that guy. He has no evidence. I have evidence of what she did to me. And I'm just asking for my story to get covered fairly. Thank you.
Well, I can promise you it will be fairly covered. And I mean that in a non-ironic, non-joking way. I will fairly cover your story. We're gonna be talking about that book, Russell. Whew. I did bring my Kindle with me. I'll get it loaded up. What? What's up, Dream Vikings? What can I do for you, buddy? take it. Hashtag swifted, hashtag not blessed. Hashtag swifted. I will work on the soft piano music. I have not done a video with a soft with any sort of musical background, but I think I can arrange it. I can arrange it. His life was ruined, I know, by Taylor Swift, and I want to make sure the world hears his story to the best of my ability. Would this guy be a better lawyer than Landau? He'd charge less, I think. So maybe. I think if you asked him, he'd tell you for sure. Oh. Thanks, Pizza Wolf. I appreciate it. His legal document wasn't nearly as funny as his video. And I don't mean to make fun of his disability, just his explain it directly has... No, and honestly, like, his disability, it has nothing to do with the insanity that he is putting forth. Like, it's not his Mobius syndrome that makes him hilarious. Okay, hold on real quick. So, yeah, let me be clear. H said hashtag swifted, hashtag not blessed, hashtag thanks, buddy. I appreciate it. And Adam Robertson said hashtag swifted. And then Pizza Wolf said love the show, even liquor free. Thank you all very much for that. I think I am going to wrap it up. His disability is Mobius syndrome. Mobius syndrome, which is a facial paralysis. Adam Robertson says Greer plus Landwy is Lautism Voltron. And it's got to be one of the knockoff Voltrons, right? Oh, gosh, there were a couple of them. I can't remember what they're called, but... Oof. Wow. Well, guys, it's 2:30. I gotta get to bed. I've got more activities to do. Again, if you're just joining the stream, or if you're watching to the end, or if you missed part of the beginning, I will be in Bremont, Texas, for the Polish Festival, Friday and Saturday this coming week. Oh, excuse me. So if you want to join me there for a drink, some sausage, whatever one does at a Polish festival, I am going to eat copious amounts of food. But yeah, if you wanna join me there, if you have the ability, send me a direct message and we'll figure out how to meet up. So otherwise, guys, thank you so much for joining me. I'm gonna wrap the stream up now, and I really appreciate it. I'll have to see I don't know if we're coming back through Dallas or not. And what our schedule will look like. So I'll let you know, buddy. But thanks, everybody. And yeah, I've got some stuff planned, so we should have some good stuff. Hopefully in a better lit room than this. Like, I get this stupid... The light of the monitor is what's lighting my face, because I can't get... The lighting in here is awful. So anyway... If I ever come to Germany, I will definitely hit you up. I would love to come out to Germany at some point. So. Thanks, Dr. Richard R. Ape. I look forward to reading it. So. All right, guys. I'm going to blank out the screen, and then as soon as it goes blank on my end, I'll end the stream. So thanks a bunch. Y'all have a good night.